our 2025 masterclass, and this has been free to the public. I decided to barely, start promoting it earlier this week. I just dropped it on the YouTube, and so I believe those that are here are meant to be here, and that's why we're doing this. Like at least 30 people had reached out to me, saying me masterclass, masterclass. I want that masterclass, but they're not here, and but those that are meant to be here are here, and so I'm grateful for those and each and every single one of you guys that are here, that are present. I would love for each of you guys to get on your guys' cameras so I can see your beautiful faces, whether you're driving, whether you guys are with the kids, whether you guys, wherever you guys are at in this world. I would love to see you guys because I want to make sure that you guys are present throughout this call. I want to make sure that you guys are actually here. I want to make sure that you are now. As he said on today's live, or on the audio that we just listened to, he talked about the awareness, and that's simply who and all that we are in this lifetime is simply awareness. See, I want you to understand we're not this body. We're not even this mind. We're not these crazy thoughts that we may think at times. You are simply just the awareness. And once you can come to the comprehension of such, your life will truly, truly, truly change. And so thank you all for being here. I've got a couple different things and documents that I put together and compiled and put together for you guys. And you guys within the mentorship will all get access to each and every single one of these. Outside of that, you guys here live will be left, whether you guys are in the mentorship or not, with at least one ebook, right? One of these ebooks that I've compiled, you guys will be able to keep access to and keep for your record and for you guys' own studies in the future. So let's get into it. So before we begin, it's important to clarify that the ideas that we're about to cover here in this chapter are based on personal theory, not universally accepted facts. These concepts arise from independent research and interpretation of U.S. laws surrounding commerce and credit. All right, so these are all things that I've personally experienced, that I've personally gone through. I'm not a guru. I never would love to be, nor like to be compared to such. I'm just like you guys, right? I'm your guys' brother. I'm, your guys' son. I'm your guys' whatever it may be, right? I am, one with each and every single one of you guys. And so I believe the power of oneness, and within my culture of being indigenous, we understand that we're not above nor below anything or anyone, and that includes animals, that includes nature, that includes, just every living thing here on this universe. And so it's important and vital to understand such. And those that do come off or seem to be a lot bigger and hold themselves as such, right? I would be wary with following individuals as such. It's all about understanding that at the end of the day, we're all one. And so the theory that positions as financial institutions, including banks and major corporations involved in extending credit, collaborate in the creation of the three major consumer reporting agencies. How many of y'all are tired of these big three, Equifax, Experian, and TransUnion, and ready to have them go bankrupt and bankrupt them? In order for them to go bankrupt, we all must be in tune with this information and with these teachings. And that's why we're about to cover what we're about to cover here. So I've got a couple different topics that we're going to cover. If y'all are ready to bankrupt them, I want y'all to, in the comment section, to drop the word bankrupt, because it's time to bankrupt Equifax, Experian, TransUnion. TransUnion and Equifax have already removed themselves from the American Arbitration Association because they were getting hit with arbitration time and time again. We're going to go through arbitration a little bit briefly today, and that's where the power comes, family, is going through arbitration, is going through litigation, is putting on our big boy pants, is putting on our big girl pants, and understanding whether or not I've gone through arbitration, whether or not I've gone through litigation, that I've got the power here within to go up against any one of these corporations and get the desired outcome. So hopefully after today, you guys are left with the information needed to help empower each and every single one of you guys. Because on my journey, throughout my from a place of gratitude and love. So being a natural person means you have the inherent ability to act independently in commerce. So in contrast, entities such as corporations or individuals acting as a U.S. citizen rely on others. That's why it's vital, and that's why I covered on that last live, to never state you're a U.S. citizen, a 14th Amendment U.S. citizen. Like the government or legal counsel to speak or act on the behalf. Recognizing this distinction is crucial to understanding one's potential role and power in commercial transactions. So the consumer as the original creditor. How many of you guys have heard that but never fully got an actual breakdown of such? Well, let's hop right into it. The central idea is that since obligations tied to the use of one social security number are backed by the U.S. government, the real power lies with the consumer, not the banks. See, in 1933, why everything took place in the 30s as it did in 1929 is because the people lost confidence in the banking system. So you guys are going to see here in one of these sub chapters that it is essential to the continued functioning of the banking system to ensure the need for the public's confidence, right? Something along those lines, verbatim, but it's vital for the banking system to continue to make sure that the people's confidence in the system is there, to make sure that you guys believe in the system, because I promise y'all, if we today over here in Vietnam, because it's Monday, but tomorrow when the banks open up, if we went to the banks and all asked to get all of our money out of the banks, they will not be able to provide us all of our money. So Congress acknowledged in 15 U.S.C. 681A that the entire banking system is reliant on the accurate and fair credit reporting. In simpler terms, the financial ecosystem depends on your credit activity. That makes you the essential component, not the dependent upon something, means that it cannot live without it. To be dependent upon water means that I cannot live without water. So while we're here right now, let's take some time to hydrate ourselves. If you don't got water, go run and go get some water, because we're going to be here for some time. So let's make sure that we're hydrated throughout this. Let's make sure that you guys, yes, are hydrating too before you go to bed. Not only when you wake up, not only throughout the day, but yes, too, before you guys go to bed. I know it's a little late over there. It's getting late. So let's make sure that we do hydrate as well. All right, amazing. So the notion that consumers create credit contradicts what most people are led to believe. According to 12 U.S.C. 1431, banks are not authorized to originate credit, rather they function as borrowers. Deuteronomy 15, right? Deuteronomy 15. How many of y'all thought, it's Sunday, I'm going to take y'all to church real quick. How many of y'all thought coming into today's teaching and today's live that you were going to hear anything from Scripture? Well, Deuteronomy 15, you will lend to many nations. This is the book of Numbers, but you will borrow from none. You will lend to many nations, but you will borrow from none. States that verbatim. Never in any transaction are you guys the borrower. You guys are the creditor in due fact, and never will you guys ever be the borrower. I want to make that very clear. Right? We'll hop more into it. But never are you guys the borrower. You guys are always the originator. You guys are always the creditor. You guys are always the creator. A creditor is a creator. In order to be a creditor, you must be able to create. So what I want you to understand is that a corporation, a federal corporation, cannot create anything. They are a corporation, a piece of paper, and they cannot go out and create anything because it's just a piece of paper. Right? We, though, have the ability, as your parents did, to create life as they created you guys. You too can also create life, and that is what a creditor is. So let me go ahead and get my laptop charged up so we don't die on y'all. Like I said, I thought I had a whole nother hour, and then I woke up and I checked the time, and I'm like, yo, We're only 11 hours and not 12 hours. But good thing I got all of this done last night. Okay. All right. Let's move this out of my way. There we go. So the notion that consumers create credit contradicts what most people are led to believe. According to 12 U.S.C. 1431, banks, once again, are not authorized to originate credit. Go look into it, 12 U.S.C. 1431. I wish we can go over and touch upon everything, but this is why I'm reading through it for you guys, for all of you guys to go through and also, do self-research. It's all public information, as stated earlier. Being a natural person means you have the inherited ability to act independently in commerce. I want y'all to write that down. Being a natural person means you have the inherent ability to act independently in commerce. Thus, methods were devised to obscure this reality by developing agencies to collect credit data. All right, y'all, we're just getting into it. Credit scores and control access to credit. These organizations inverted the original power dynamic. So understanding the legal framework, Title 15, Chapter 41. So to navigate this system intelligently, it's vital to understand that consumer law governs these transactions. Title 15 of the United States Codes, particularly Chapter 41, contains several subchapters, including the Big Three. I want y'all to write down the Big Three: Truth in Lending, the FCRA, and the FDCPA. All right, Truth in Lending starts at 15 U.S.C. 1601. Let me go ahead and escape and take you guys out of here really quick. How many of you guys are gaining some information thus far? Even if it's just one thing. Even if it's just one thing. How many of you guys have taken away one thing today? So I'm going to take you guys here. This is 15 U.S.C. 1601. This is what it should look like on cornelllaw.edu. Let's go ahead and widen the screen for you guys. This is the Fair Credit Reporting Act, and this is 15 U.S.C. 1681. I want you guys to write down two things. I want you to write down congressional findings and definition section. Each subchapter is going to have both. All right, each subchapter is going to have both, and it's vital to understand both pertaining to that certain specific subchapter as well, because there may be some words that are used in multiple of the subchapters, but that may have a slightly different meaning. So 1601, 1681, and 1692. Okay, we got some children's books as well too that we're going to be going over here on today's live. Okay. Each one of these laws addresses specific assets of consumer protection and credit rights. Through length, they collectively offer a power toolkit for anyone seeking to assert their rights in commerce. This chapter focuses primarily on the most impactful of elements of TILA and FCRA, providing a working understanding of how the system functions and where consumers' authority lies. All right, so some key legal definitions to understand. Before going further, it's helpful to look at definitions from federal statutes, starting with Truth in Lending's definition of a credit card, 15 U.S.C. 1602. The term credit card means any card, plate, coupon book, or other credit device existing for the purpose of obtaining money, property, labor, or services on credit. I want you all to pay attention to words like any plate and services. These terms are powerful when properly understood. Any implies to no limitations. It covers all forms of credit-bearing devices. So any card, right, any plate, and any service. Plate may symbolically represent license plate, which often contain numeric identifiers and are used in contexts involving contracts or commercial transactions. Services refers to utilities and other recurring obligations. Services often activated by supplying your social security number, not a conventional bank issued card. So services can once again be your lights, your utilities, right? How many times have you guys ever been asked to provide a credit card from Bank of America or from American Express when going out and with ARS, turning on your utilities or whatever power service that it is that you guys use? How many of you guys have ever been required to provide a credit card of one from Bank of America, Wells Fargo, Chase? No, but every time they ask for that 9-digit social security number, that credit card. All right, this understands challenges traditional beliefs. Institutions typically present credit cards as plastic instruments issued by banks, but federal law defines them far more broadly. These details, often omitted from mainstream education, are key to reclaiming agency over these credit interactions. Decoding credit under the federal law. So the legal definition of a credit in pursuant to 15 U.S.C. 1602 F is the right granted by a creditor to a debtor to defer payments of debt or to incur debt and defer its payments. The phrase right granted is significant. It reveals the ability to extend credit must be bestowed, not assumed. It's not a privilege, it's a right. This contradicts the mainstream interpretation that financial institutions alone originate credit. In truth, the original creditor, you, grants them that right. And think about a grant, right? There's certain qualifications that you must meet in order to receive a grant. Right, I want you all to think about. I want you all to think about a grant. Let's go ahead and put these paintings down. In order to get this grant, all right, let me put those back. We had the window open last night because it was coming down and thundering and all of the above. Without this awareness, consumers can be manipulated into believing that they are mere debtors. Understanding the language of the law is essential for reversing the mindset. The role of the natural person in credit organizations. In the legal context, so I want you to understand that we're going over definitions right now, definitions within truth and lending. And this is what's going to help you guys all understand consumer law, is just understanding the definitions. So it's vital that we have an understanding of such. And so I've just compiled about 4 pages, so we only got a couple more pages of this one right here, and then we're gonna dive into a couple different ebooks. I've got some children's ebooks for you guys. We're gonna also go through the AI debt terminator. If you guys have any questions as well too, and we'll have a break as well. We'll have about a 15-minute break. But if you guys have any questions or anything specifically that you would love for me to cover here on this masterclass, I'm gonna go ahead and drop my email. Any documents you would love for me to cover, anything that you would love for me to help you guys respond to, go ahead and email me. Email me those documents right now. We'll have about a 10-15-minute break actually, so do it during that break so you guys can be present throughout the rest of these teachings. But we'll have a 10-minute break here in about 30 minutes, and within that break and coming back following that break, we'll be able to go over those questions that you guys have, those documents that you guys have, so it can also to teach other people as well. If you guys want help drafting up a specific letter, let it be known, and we'll cover that here on this masterclass. So I want that to be known as well too. So you guys aren't just coming in and taking notes. You guys are all able to get any question answered as well. We'll have a Q&A, and then if you guys have any documents or any files you guys want help responding to, we'll have that done exactly here on this live as well too. I will have a whole letter drafted out for you guys, everything for you guys. So let's hop right into the rest of the teachings. Consumers who understand the legal origins of credit can begin reclaiming their financial power. They also better understand why consumer reporting agencies emerged to obscure this reality and reframe the consumer as a liability rather than the originator of credit. I'm gonna say that part again. I believe that went over a lot of you guys' heads. Consumers who understand the legal origins of credit can begin reclaiming their financial power. Deuteronomy 15, once again. They can also better understand why consumer reporting agencies emerged. There's over 330 consumer reporting agencies that are reporting different things from insurance, that are reporting different things to your driving record, that are reporting different things to public records, that are reporting different things to, you name it. There's consumer reporting agencies you didn't even know existed. Over a check-ins account, check system, early warning, LexisNexis, they're furnishing bankruptcies. LexisNexis, they're furnishing anything on your driving record, any tickets that you've gotten. Right, they're furnishing all of that information without you guys even knowing. Right, that license plate, once again, is also to a credit card. So anytime that it is being pulled, a finance charge is arising. Anytime that a finance charge has arose, anytime that you've been entered into a credit transaction, a finance charge arises. So anytime your credit card is ran with utilities, with you getting pulled over, with you going through to the bank and setting up a bank account, with you going to the bank and setting up a credit card or any line of credit, right? They're using that credit card. And credit is arising. Anytime that there's credit arising, there's a finance charge that too arises. And that's why with every transaction, there's a truth in lending disclosure, or there should be at least. All right, so let me read back through the role of a natural person in credit origination. Let me read through this whole, section again. In legal context, a person can refer to either an individual or an organization, but in commercial credit law, it is the natural person. One born naturally, not legally formed, who possesses original credit authority. That's why as a creditor, you're born naturally and you create naturally, and you have the ability to recreate and create at will. We have the ability to contract with any of these corporations, to recontract with any of these corporations after we've gone through and discharged with them, and do it at will, whenever, however many times we want. This is that open-ended credit plan. This is why the careful use of language and definitions is so critical in these discussions. That's why it's important and vital to understand the definitions of these chapters and sub-chapters that it is that you guys are using. To stop looking on Webster and Merriam Dictionary and start using Black's Law Dictionary and start using the definitions within the sub-chapters of whatever chapter or sub-chapter that you're using. So understanding when certain laws were passed provides additional context. So like I said, in the 60s and the 70s, right, JFK in the early, 60s and, was teaching this information. TILA informs consumers of the true nature of credit. So truth in lending, what does it do? It informs consumers of the true nature of credit. This was passed in 1968. 1970 and 1971, the FCRA was passed. It regulates how credit information is being reported. Wow, I thought, credit was something that was fairly new. This is something that's been going on. The FDCPA. Okay, now debt collectors started getting involved and started, buying these debts from these reporting agencies and buying these debts from these banks and financial institutions and buying them in bundles, and they're buying them for pennies on the dollar. It restricts abusive debt collection practices. This sequence shows an evolving legal response to growing institutions, misuse of consumer credit information. So those were when those three subchapters were passed, and it's vital to understand when they were passed to show you guys and shed light upon, this isn't something that's new. These are things that have been taking place time and time again for decades. Civil and criminal liability in TILA. So most Title 15 statutes include civil remedies for violation. However, TILA emphasizes criminal liability for willful violations before civil penalties are even considered. If a lender knowingly conceals finance charges or fails to disclose rights such as rescission, they may face criminal charges. Quoting these provisions during disputes can often lead to quick corrective actions from violators who wish to avoid legal consequences. I'm going to read that again for you guys. Most Title 15 statutes include civil remedies for violations. So within the FCRA, we got 15 USC 1681N, as in Nancy. We've got 15 USC 1681O, as in orange. We've got 15 USC 1681Q, as in queen. That's 3 that will show you guys how you guys can get hold these corporations civilly liable or criminally liable. Now within truth and lending, we got 15 USC 1611. All right, we got it talking about with each violation leading up until 1611, you guys can get up to $5,000 per violation, or they can be criminally, charged for up to 2 years of imprisonment. Then we got 1640, which talks about double the finance charge. 15 USC 1640. This is also in truth and lending. Double the finance charge per each violation. Then we've got 15 USC 1692K, which is the civil liability within the Fair Debt Collection Practices Act. All right, so if a lender knowingly conceals finance charges or fails to disclose rights such as rescission, right, one's right of rescission, they may face criminal charges. Quoting these provisions during disputes can often lead to corrective action from violators who wish to avoid legal consequences. So, final thoughts. This chapter is an invitation to reflect deeply on your role within the financial system by understanding the legal definitions of the power they grant. You position yourself not as a passive participant, but as a key originator within the entire credit ecosystem. Study these statutes, which we're about to dive more into here in a second. Understand these words and the definitions. And above all, recognize the authority that you hold as a consumer. All right, so we compiled that a while ago. This is my first time really sharing it with you guys. It's going to be bits and pieces of our book that we have dropping. And so without further ado, I'm going to be going over a couple other books that we've already dropped. So any questions thus far? Right of rescission. So you guys can see that. Reflect 15 USC. It's a right, like, a God-given right, just like all of these are rights. It's a right, R-I-G-H-T of rescission. 15 USC 1635. Great question, though. So let's hop into the story of TILA and protecting consumers. Once upon a time in the year of 1968, I'm going to take you guys back to story time. It's preschool. Like I said, like we did earlier on this call, we went through and we visualized and we spoke words of affirmation. I am, I am, I am, I am, I am. And we sat there and we were and we were just meditating and we were just visualizing and we were just dreamcasting and dreamcasting. And we were setting the intention, today I want to get this out of the call. These are things that we did as 5-year-olds, as 4-year-olds, as 3-year-olds, as little kids. We were dreaming. We were dreamcasters. We told the whole world our dreams. We dreamt big, right? We didn't have any doubt on our dreams. We thought, when I get older, I'm going to do this. When I get older, I'm going to see this. I'm going to go to these places. I'm going to do these things. I'm going to, where and when did this stop? It's when society got our hands on us, when this system started programming us, when the schooling system started placing these programs onto us. When it started to place these limiting barriers on us, how can one limit the limitless? How can one limit the limitless? So that's why I wanted to go ahead and cover a children's ebook for you guys and take you guys back to story time. Right? It's story time right now. The story of Tila. Let's hop right into it. Something important happened. The grown-ups wanted to make sure everyone understood something called the Truth in Lending Act, or TILA for short. You see, back then, some people weren't being treated very nicely by lenders, so Congress wanted to change that. Think about the name, Truth in Lending. Somebody was not being truthful while lending, so therefore Congress passed TILA. They looked closely at what was happening and found something important. Right? Congressional findings. This is what Congress found. They discovered that many people didn't know the truth about borrowing money, about lending, it should say. Congress found out in a specific way called congressional findings. But they also learned that when people use credit wisely and know the truth, it can help our economy and make banks stronger. This is a start to explaining the background of truth in lending. You can continue the story by breaking down the key provisions of TILA in a simplified and engaging manner while using illustrations to make it more child-friendly. Remember to keep the language and concepts suitable for young readers. Okay, last page of that one. We still got some refinement and some things that we are adding and removing from such. So who here, drop a 1 in the chat box, because this is pretty often, I see this quite often. The late payment, late payments on individuals' credit reports. So this is the late payment blueprint, a children's guide to fixing your credit. So here's a couple steps that we're gonna have and that I want you guys to write down and do as you guys are going over your report. We're gonna hop into our administrative process, right? The grown-up administrative process. Here in a second, but before we do, I'm going to cover a couple of these children's ebooks. So why is this important? Step number 1, to look over your reports. To start fixing late payments, you need to see your credit reports from Experian, TransUnion, and Equifax. So I need you all to go to annualcreditreport.com and request your reports from Equifax, Experian, and TransUnion, and then from there, download them and print them out. Next step, step 2, is to look over your reports. Right, an example might show some late payments, such as 30 days late in November and 6 days late in December. A lot of times they'll put 30 days and 30 days late. That's what it should say. So 30 days late in November and still 30 days late in December. Right, that should be fixed. It shouldn't have a consecutive, months of 30 days late and 30-30. If it doesn't say 30, 60, 90, that's an inaccuracy. Any inaccuracy that you guys spot on your consumer report, can and should be removed, and we'll hop right into that here in Truth in Lending. The Fair Credit Reporting Act, because the banking system is dependent upon who can drop it in the comment section. Right, I know this. The banking system is dependent upon what? If you guys first person comment, I got another ebook for you guys. The banking system is dependent upon what? Okay, if you find mistakes, take screenshots of the errors, highlight it, write it down, write down a violation of such. Okay, this is a violation of the FCRA, 15 USC, 16 what? Not consumers. The banking system is dependent upon what? Go look up 15 USC, 1681 real quick, verbatim. Look over your reports. Credit can't always prove if you were late. They just say that your payment didn't go through. So write a letter to the creditor explaining the mistake and include screenshots of the error. After that, we send a letter to the consumer reporting agencies, or to the creditor, and how to trap them. We send a notice of dispute to letters to TransUnion, Equifax, Experian, with the information that you sent to the creditor as well. And then we're going to use tools like AI. I've been able over the past year to program my own AI, and we're going to cover that here in a little bit. It's called the AI Debt Terminator, and we're going to go over it here soon. So start to utilize these tools as such. Send the letter to the creditor. What to do next? Sit back and wait for the credit reporting agencies to respond to your dispute. What if they don't comply? If they don't, you have 2 options: litigation or arbitration. What is pre-arbitration? So before we go through arbitration, I like to send out a pre-arbitration letter. It's a step where you can settle without going to court or without going to arbitration. It shows how they can't prove the late payments, and it outlines the fees. What if they don't comply? How to make them listen, show them how much they will lose if they don't fix your report. So once we start talking numbers and going through arbitration and listing out the filing fees and listing out, all of the fees and fines that come with arbitration and litigation, they're going to start to move accordingly. Show them the cost, including your letter, how much it will cost them in attorney fees and arbitration. Use their own agreement. Go to adr.org. So let me take you guys here right now to adr.org. So how can I find out the fees and how much the filing costs and how much they're going to be having to pay on their end? Well, we'll come here to adr.org. We'll go to the consumer section. On the consumer section, we'll go ahead and there's the fee schedule that you guys can go ahead and select. And then if we scroll down to view the consumer arbitration clause, this will actually allow us to pull up their agreements. And so if they are regulated by the American Arbitration Association, they will have their arbitration agreement within here. Drop a bank that you guys want me to help you guys find the arbitration agreement. Drop a bank in the comment section. Any bank that you guys may be dealing with, drop in the comment section. And I got you guys. Any banks, let's see. All right, the banking system is dependent upon fair and accurate credit reporting. So what that means is that yes, it is dependent upon our credit. So close, Rashid. It's dependent upon our credit, but fairness and accuracy. So if there's anything that's inaccurate, yes, Capital One, let's see, let me show you. Capital One, they don't have an arbitration agreement, so you must take them through litigation. So if they don't pull up here, then they remove themselves because they were getting hit, by so many consumers with different filings of arbitration that they remove themselves. Just like we'll see Equifax isn't in here. They must have just added themselves back. That's good news. Experian is also in here. Yeah, Equifax just added themselves back, which is great news. That's me just finding out. Wow. I gotta double that back. Yeah, 9/18/2024. Wow, let's see if TransUnion is under here too. Okay, I know Equifax and TransUnion removed themselves because they were getting hit with so many lawsuits or so many filings through arbitration. Wow, that makes me actually very happy. I got something for y'all too now for this. Okay. See, I know originally, and this is the address you guys want to use as well. These are the addresses you want to use. I'm going to download that and I'm going to play with it. And everybody that was here as well, I'm going to drop a letter for you guys, following such. Specifically for Experian and Equifax and going through arbitration. I can't spell. Okay, and this is the address you want to use for Experian. 475 Anton Boulevard, Costa Mesa. Okay? How many of you guys have heard of that address? Drop a 1 in the chat box. If you have, drop a 2 if you have not. So this is the American Arbitration Association. This is how you guys will go through and file as well. Here's the form that you guys will fill out when filing arbitration. So if you got anything that's inaccurate on your consumer report, anything that's inaccurate, you guys can dispute with them, put them on notice first, send out a notice of dispute, and then you guys are going to notice within these agreements and contracts, it states if there's any claims, anything that we cannot agree upon, that it must be handled, that it should be handled through arbitration. Agreement to resolve all disputes by binding individual arbitration. Any claim as defined below raised by either you or Equifax against the other shall be subject to mandatory binding arbitration. So it doesn't say let's keep disputing with them and going back and forth. Once I put them on notice, I've let them know, okay, putting you on notice of the inaccuracy reporting. If they come back and they state that, oh, this is accurate, this is verified, without providing proper debt validation or verification, okay, then I'm going to give you guys one more chance with my pre-arbitration letter. If you guys are not willing to comply with the pre-arbitration letter, I'm letting you know in this letter that I'm willing to take it through arbitration. I'm going to let you know the money that you guys are going to lose out on going through arbitration, because when we're talking about businesses do not want to lose out on money. They're just a business themselves. We're going to go over 10K filing forms as well too. I'm going to show you guys actually a letter that I drafted up for my stepfather, who is actually being hit with the lawsuit, and I'm going to update you guys on this as well. It's all new, brand new, things that just arose. I'm going to tell you guys, I'm going to read to you guys the messages that he had sent. Like, yo, he wasn't he didn't come to me stressed, but my mom let me know, yo, he is stressed out to the max with this. We're thinking about just settling, but we know that you can handle this. So is there anything that you can do to help? I'm like, Mom, we not settling shit. I got y'all. All right, this is all we've been doing, what we've been doing. And this was got me into this information as well too. And like I said, I'm no guru. I'm just like y'all, right? This still arises in my family's, life as well too. To where it's like, okay, that's where the power comes. That's why I've stopped taking on credit repair clients, and I'm just simply taking on individuals that want to learn for self. And other than that, I'll teach you guys on YouTube, because when this arises again, I don't want y'all to continue coming back. A business where people are just continuously coming back for the same things isn't a legit business, right? Hospitals are not legit businesses, right? I don't want you guys coming back for the same thing. I want y'all coming back to build with me, to grow, because you guys have already gotten an understanding and, gone out and gotten the results from the first part, to where now we can go out and now we can build and invest together. After we've invested together and created more cash flow, now we can go out and we can buy land together. We can build communities. We can give back to, other communities. All right, we can start nonprofits. We can start doing these things. I don't want to be teaching the same thing for years to come. Okay, so once again, any claim raised by either you or Equifax against the others shall be subject to mandatory binding arbitration. Does that make sense? It's going to say that just about verbatim in each arbitration agreement. What I want you guys to do as well too, if you don't already have an Experian or Equifax account, they're free. Go to Equifax.com, go to Experian.com, and set up an account with them as well too. Set up that free account. If you guys are looking to file arbitration, right, we're gonna also want, because in order for this contract to be applicable, we must actually have, done business with them, and going through and setting up an Experian and Equifax account is now, making this arbitration agreement applicable, right? We gotta have that. We gotta actually have an account with them. Yes, they're reporting on our behalf, and but we haven't contracted with them, and so set up that Experian and Equifax.com. All right, family. So let's get back into the teachings. How many of you guys drop billions in the chat box, the word billions, if you guys have taken away at least one thing, if one thing has resonated with you guys on today's teaching so far. So now we're going to hop into real world scenario. Billions, I love it. Great for you being here, Rashid. I'm grateful to actually put name to face as well too. I know we've gone back and forth, communicated a little bit, but I'm grateful to actually, put name to face. And I believe it's the energy just hits different. And Billy, not Billy Calvin, billions. It hits different when I'm able to actually just, connect with you and, see your face, see your smile, and, just y'all are able to do the same, because I don't want y'all to look at me as some figure online and somebody you guys just watch. Like I said earlier, I'm your guys' brother, I'm your guys' sister, I'm your guys' friend, I'm here, I'm for you guys, I'm, no different than you guys. I don't want you guys to think, oh, he just travels the world and he's all these places, and you too, and I want y'all here too with me doing these things as well. And so it's vital that we get this information down. I love it. I love it. Billions, billions. Billions. Not in terms of monetary billions, but in terms of the lives that we're gonna go out and empower. Billions of lives. So let's do it. Real world scenarios. After this, we'll take a quick 10 to 15 minute break, and then we'll hop right into the second part of the teaching. So, credit reporting disputes, legal frameworks, and real life applications. All right, I see y'all too. I see y'all tuned in here on YouTube. I see y'all tuned in. Billions, junkie nuts, always tuned in. I love to see it. I love to see you here. 8 figures tuned in. Sin Ironheart. Y'all got to be on the Zoom, though. I love that y'all are tuned in here on YouTube, but y'all got to be on the Zoom. Y'all got to be on the Zoom. If you guys are not on the Zoom, text 305-575-2843. I'm going to say it one more time. 305-575-2843. And yes, we're going to be texting you guys from another number outside of, I'm going to personally text you guys from my personal phone number because I'm in a whole other country. So our 305 number is not working right now. So I'm going to text you guys from my personal number and send you guys the link to this here following our 10-minute break, so you guys can actually see the screen and see the teachers and not just see my beautiful face and me sitting crisscross applesauce and Zen, posture, but actually able to see the teachings. All right, so repossessions. I know a couple people got repossessions here on this live. So let's say your car, here's a real life scenario. Your car was repossessed after missing a few payments. However, the creditor falsely reports that you still owe the full balance of the loan, even though they sold the vehicle at the auction. Because when they repossess your car, they're going to send you, we're going to auction off your car. Even though they sold the vehicle at auction and applied the sale proceeds toward the loan. So after they do, sell it, they're going to deduct the amount that you owe. And if they sell it for more than what you owe, they're actually supposed to pay you guys. Well, whatever they do deduct, let's say you owed $10,000 and they sold it for $8,000. Well, now it should be reporting $2,000. If it's not reflecting and reporting as $2,000 on your consumer report exactly, if they're still reporting $10,000 owed, that's an inaccuracy on your report. Or let's say it was 2050, that they reported. Well, because they're trying to get extra fees and whatever it may be. That extra 50 is inaccurate, right? You guys are saying that, okay, you guys sold it for $8,000. Well, only $2,000 should be reporting as of what you guys sent in this letter, but you guys are reporting $2,050. Right, so it should reflect exactly as such. You guys can use then 15 USC 1681 S2. Let's go ahead and take you guys here to 15 USC 1681 S2. All right, we're here, so we're gonna go through and I'm gonna show you guys as well. Y'all aren't just gonna be able to see it, or hear me, but y'all will be able to see it as well. 1681 S2. A person shall not furnish any information relating to a consumer to any consumer reporting agency if the person knows or has reasonable cause to believe that the information is inaccurate. right? A person shall not furnish information relating to a consumer to any consumer reporting agency if the person, we got to remember as well too, and anytime there's a definition underlined, that means that that's for you. That's for you guys, that definition. So we got to understand the definition of a person as well too. It means any individual, so any natural person like me and you, partnership, corporation, trust, estate. So a lot of times when they state person in these contracts, they're also referring to corporations. Has been notified by the consumer. That's the power of us. We have the ability to act on the behalf of the natural person or the organization. Don't let that go over your head. The person has been notified by the consumer at the address specified by the persons for such notices. That specific information is inaccurate. The information is, in fact, inaccurate. All right, so this is what we're covering here on this ebook right here. You can use 15 U.S.C. 1681 S2A to dispute the inaccuracy as creditor is required to report the correct balance. If they fail to correct the information, Collins versus Experian case supports your claim for removal. How can I look into Collins versus Experian? This is just some law that I've heard of, maybe, that you're talking about, Gotti, but like, how can I actually look into it? How can I go ahead and go in depth with understanding such? Well, we can come here to Collins versus Experian on pacermonitor.com. We can click on it. My account's not active anymore. And then you guys can go to the docket, and then the docket, you guys can go to the, the consumer complaint, the first one, like scroll down to the bottom and see what they filed first. You guys can also just Google this, Collins versus Experian. But all public records will be found here on Pacer Monitor. So quick note as well. Equifax, Experian, TransUnion, LexisNexis. How is LexisNexis getting these bankruptcies and reporting this information? They use a system. You guys may have heard of this called the Pacer system. This Pacer is what I just showed you guys right here and right now. And you guys will see that there's different subscription base that will allow you to go and pull even more, public information. And I'm sure, certain information or bankruptcies that pop up, they're alerted of such. They're aware of such. All right, I'll get to the questions here soon. I'm almost done with the teachings. So this is for repossessions. Case law study. Okay, so let's see. Collins versus Experian. Top of the rise now here is 741. So y'all can go through and read 15 U.S.C. 1681I. So on January 15, 2015, this court reversed the district court's determination that third-party publication is necessary for a consumer to be entitled to actual damages under 15 U.S.C. 1681I of the Credit Reporting Act, which requires a consumer reporting agency to conduct a reasonable reinvestigation of disputed information contained in a consumer's credit file. We remanded to the district court further proceedings in Curtis J. Collins' claim alleging a negligent violation of 15 U.S.C. 1681IA. We affirm the district court's grant of summary judgment on Collins' claim that Experian willfully violated its duty to conduct a reasonable reinvestigation under 15 U.S.C. 1681I. So we're not going to go through and read through this whole case, but you guys see everything that we're touching on and talking about. Yo, damn, maybe he does know something. That's why everything that I teach though and provide for you guys has case law study. It's not something I've come up and created. It's just things that I've gone through and educated myself on and read through and spent hours doing such. But now we can do it in seconds with this AI that I've compiled and configured. Whew. Let's get some water. Quick water break. Quick water break. Make sure to stay hydrated. Make sure to stay hydrated. I'll say the number again. 305. You write it down. Maybe y'all drop it in the comments. 305 575 2843. 305 area code Miami. 575 2843. All right, now charge-offs. I know a lot of you guys have charge-offs. A lot of you guys are dealing with charge-offs. So let's say you notice a charge-off listed on your credit report, but the balance is reported incorrect. What you can do also is use what we use in that Collins versus Experian 1681I. After you guys have sent off a notice of dispute and they state that it's accurate or it's verified, well, that's not, proper reinvestigation. If you look in the definitions of, like I said, know these definitions, you guys will see what should be done through an investigation. And then it's called an investigative consumer report, something along those lines. You guys will see it, investigative consumer report or reinvestigation or something along those lines. What should be done through properly stated in the FCRA's investigative consumer report. Under 15 U.S.C. 1681G A1, you can request detailed records of the debt and dispute if the numbers don't add up. And there's a Pintos versus Pacific Creditors Association. There's also Cushman versus TransUnion. So there's two case law studies here. We've got Pacific Creditor or Pintos versus Pacific Creditors Association and Cushman versus TransUnion. The Pintos case supports your right to dispute even if the charge-off is valid but inaccurately reported. So now we're hopping into collections. A debt collector reports a debt to the credit reporting agencies without informing you, or they continue to report it after you've issued a cease and desist letter. You can use 15 U.S.C. 1692E to dispute the inaccurate information or stop further reporting and cite Daugherty versus Convergent. Right, so a debt collector reports a debt to the reporting agencies without informing you. How many of you guys have ever had a debt, on your collections, a debt collector pop up and you're like, yo, I've never done business with y'all. In this lawsuit that, that they, summoned my stepfather with, in the response, I'm going to state something verbatim along these lines. And yes, I did use case law study as well in my letter. I sent in a affidavit to them, and then I sent in, I helped them file something back towards them as well. Okay. You can use 15 U.S.C. 1692E to dispute the inaccurate information or to stop further reporting. So we got 1692E. Also, we've got Convergent Outstanding Inc. Daugherty versus Convergent. Then we got Dennis versus BEH1 LLC. So here's a real life scenario for inquiries. Oftentimes for inquiries as well, you guys can simply pick up the phone, call Equifax, call Experian, call TransUnion. For Equifax and Experian, use those two addresses that we just showed here on this video and dispute through that. But you guys can honestly pick up the phone and call them and get it removed typically within 24 hours by picking up the phone. You apply for a loan, but weeks later you notice unauthorized hard inquiries on your report under 15 U.S.C. 1681B. You can dispute these inquiries as unauthorized. That's permissible purpose, 15 U.S.C. 1681B. In order to furnish anything, they must have your written consent or court jurisdiction. So with bankruptcies, this is also great, 1681B, permissible purpose, to get those removed because you guys can go through and dispute with LexisNexis, and you guys can go through and request from the courts, if they've given LexisNexis, permission to furnish this information, because I promise you they have not. Okay, now we got bankruptcies. A bankruptcy you filed years ago is still shown on your credit report beyond the allowed reporting period. All right, let's say it's after 7 years. Using 15 U.S.C. 681, you can dispute its presence. And Henderson versus Santander supports your claims if the credit reporting agency does not properly verify the bankruptcy. So, like I talked about in 681B, you guys can go through and dispute with LexisNexis, catch them in a trap, and they're going to tell you guys that, they got permission, then we're going to the courts, where the courts are going to write to us and state that no, we didn't give anybody, permission or verification to go ahead and furnish this information. From there, we caught them in a trap and a lie. Now we go through and then we could dispute with them. We could file arbitration. We could file litigation against LexisNexis. And so bankruptcies, we've got a whole training. I believe I got it even on YouTube on the public channel, showing you guys in depth with such. Next, we got the method of verification. So let's say that you guys do send out a dispute, and let's say that they do verify it. Well, under 15 U.S.C. 1681I, you request their method of verification, but they fail to provide adequate documentation. Citing Cushman versus TransUnion, you can challenge their process as insufficient verification methods are grounds for removing the disputed items. Also, what we went over earlier with Collins versus, what was it, Experian, or Collins versus, Experian. That one also used 1681I. As insufficient verification methods are grounds for removing the disputed items. So we got Cushman versus TransUnion and Experian versus Experian, or Collins versus Experian. Reporting a debt as disputed. So let's say you find an error on your credit report. How many of you guys have found one related to a collection account, and you send a dispute letter to the creditor, notifying them of the mistake? So we spotted the inaccuracy. However, the creditor continues to report the debt to the reporting agencies without marking it as disputed. Well, under 15 U.S.C. 681 S2A3, they are required to flag the debt as disputed while the investigation is ongoing. If they fail to do so, you can reference Saunders v. Branch Banking and Trust Co. to support your claim. I'm going to say it again. Saunders versus Branch Banking and Trust Co. You guys can also use the Pintos one, the Pintos versus Pacific Creditors, and the Cushman versus TransUnion. All right, and this is once again to support your claim that the failure to mark the account as disputes violates the FCRA. So thank you for going through the credit reporting disputes legal framework. I know for a fact all of you guys have at least one of those that resonates. Drop a 1 in the chat box if you have at least one of those that does resonate. Okay, now we got questions. Now it's time to answer some questions. Let's see. Perfect. And the biggest thing is, citing case law study as well, going through these cases with AI, having it draft up and spit out the verbiage that was used in that complaint. That's why I like to go through the complaints, and with those complaints that they filed and that helped these consumers win, that helped Collins win. Okay, AI, go through and break down what verbiage, what points, what claims were used on Collins and on Collins' behalf to help them win the lawsuit against Experian. What helped, what was out there, Pintos win his lawsuit? What claims did he use? What consumer laws did he use? Use the same verbiage that was used in this letter as well too, that I'm about to provide for you. Here's my situation, here's my story, boom, and break it all down. Okay, I have two companies they call almost every day, Portfolio and Midland. I'm just wondering what happens if you opt out of all the secondary bureaus. Will that stop you from getting credit once you do fix credit? If you do opt out, you can always opt back in. But I never recommend opting out. I recommend just pulling those reports, pulling the reports, and let me show you something as well too. There's really no such thing as a secondary reporting agency. They're all just reporting agencies, right? So let's see, list of consumer reporting agencies. So we can see here that there's a list of over 330 consumer reporting agencies. Here's a 2025 list of consumer reporting agencies. Let's see, let's download the PDF. If we come here, we can see that, like I was talking about earlier, it tells you what to do as well. It says request your report from the companies, often for free. Next, review it. Find the inaccuracies. Kind of like, your process. Number 3, dispute it. Notice of dispute. And then from there, we'll cover everything else I'm about to go through. We've got some more ebooks that we're going to cover as well too with you guys. Let's see, we've got, where's she at? Okay, she didn't download. So I'm gonna go ahead and download it here in a second, but I got another one. I got our administrative process ebook that I'm gonna go through with you guys. I believe it's our 9-step process. So here's Equifax, TransUnion, Experian, how to get the reports, annualcreditreport.com. Here's a phone number as well you guys can call. Here's addresses where you guys can request these reports from. Okay, well, I know about Experian, Equifax, and what about reporting agencies that are affecting me from getting a job? Okay, with this typically Accurate, ADP. How many of you guys have had ADP screening? Assurance, backgroundchecks.com. This is why I teach consumer law as well, because everything in consumer law is applicable to getting these reports, cleaned up, removed any information on there, any reporting of any accounts, checker.com. Right, maybe you guys have heard of these, seen these accounts, Experian Verify. When it comes to, you renting out, a place as well, like an apartment, they're checking these as well, tenant screening. We got Appfolio, we've got AmRent. AmRent's a real big one, including employment and income verification. We've got Experian Rent Bureau, we've got Contemporary Information Corp. How many of y'all did not know that there was this many reporting agencies? Here's their website. Here's where we can pull their reports. Here's where we can request a report through their address. RentGrow is another big one as well. So if you guys have been denied, you guys can ask, what reporting agency did you guys pull from? Okay. Now you go through and you pull your report from them, as it's stated. You review them, find the inaccuracies, find the violations, and then you send out that notice of dispute. Check system. This is for checking accounts. Cross-check, early warnings, global payment. There's tons and tons. Personal property insurance, A+, Arity. There's tons. LexisNexis. Medical bills and medical information. If y'all got medical bills on your report. Low income. Microbill. Teletrack. Supplementary reports. Innovis, another big one as well. This is the secondary reporting agency that a lot of people talk about. SageStream, LexisNexis. Telecom and utilities. You guys got a collection account from, let's say T-Mobile, AT&T. Also, you guys can come here as well. And I'm gonna pull up all of the regulators when we get back from break. We're about to go on break here for about 10 minutes. It's top of the hour, so we'll go on break for about 10, 15 minutes. So once again, let's say not the OCC. Communication. The FCC, the Federal Communication Commission. So if you guys are dealing with anything from Cox, T-Mobile, AT&T, any of those that are in collections, you'll want to file a complaint through here. So I'll give you guys and show you guys all the complaints, where to file complaints. Certain regulators, we got the OCC. We've got the FDIC. We got the SEC. We got the BBB. We got the Attorney General. Of course, we got the CFPB. These are all places where you guys can go through and file complaints. And everything when it comes to consumer law is all applicable. Right, so before we go on break, I want to leave you guys with this. Title 15. So who here, drop a 3 in the chat box if you guys are aware that the United States is a federal corporation. If not, I'm going to show you guys how it's a federal corporation. 28 U.S.C. 3002, number 15, defines the United States as a federal corporation. Who here, drop a 6 in the chat box. Drop a 6 in the chat box if you have a corporation. Drop a 6 in the chat box if you have a corporation. Okay. So I see some are aware and some got corporations. Well, so what's the sole purpose of a business? It's commerce, right? Everything is commerce. Everything is, to generate revenue in a business. At the end of the day, that's what business comes down to, is to make money. All right, so if I understand everything is commerce and trade, everything is commerce. The United States is a federal corporation, so in Title 15, the name of this is Commerce and Trade. Now, if I come here to 41, in regards to anything, now we know what credit is and know what a credit card is. Anything in regards to credit can be handled here in Title 15, Chapter 41. Notice how I didn't mention anything about the UCC or any of these other due processes. I'm telling you guys about the big 3. Truth in Lending, the Fair Credit Reporting Act. There's also the Equal Credit Opportunity Act if one's been discriminated against. And we've also got the FDCPA. Don't overcomplicate it. Don't get lost in the sauce and going down these rabbit holes when it comes to one's credit report. I want y'all to understand, all we need to use is Title 15, Chapter 41. All right, fam, we'll be back in 10 minutes. I'm going to play some high vibrational vibes, some music for you guys. We will be back at 8:15, so about 13 minutes. So 8:15, we will be back. I'm going to go to pause the recording, and I will see you guys shortly.
Recording stopped.
This is something I play everywhere that I go, all around the world. Y'all want to hear it? Who wants to hear it? All around the world, all around the world, all around the world. Because at the end of the day, this is all that it is and all that it comes down to. What the heck? This should be the first one to pop up. All right, from right now, during this break as well too, send in any documents that you want me to cover, Billionaires Club at gmail.com. Send it over.
Let's get together and feel alright.
All right, family. If y'all are not a part of the masterclass, I'm gonna go ahead and end this here. Make sure to text us at 305-575-2843 to get access to the mentorship. The masterclass. I appreciate you all tuning in. Thank you all for being here. Thank you all for being present. Y'all can also check the community. In the community section, you guys will see that I went ahead and I dropped the number and the directions to get access to this masterclass. It's a free masterclass. We're just getting started. We got about another hour left, so make sure to tune in, family. If you guys got anything that y'all want me to cover, make sure that you guys send in those documents. So we're about to be finishing up the masterclass here live with everybody that's in the Zoom. You guys are more than welcome to join. Just follow the directions of texting that number, the word masterclass, and we'll send you guys over the directions. All right, family. Peace and love.